Hello, I'm Kevin Donaghy. I'm an attorney with Brokers.Law. Today I'd like to go over the steps involved in selling your company. This is just an outline, it's an overview. Additional information can be found on our website on Brokers.Law, where we go into each of these steps in greater detail. Okay, first is going to be pre-sale preparation. This is legal and financial and operational reviews to make sure that your company is ready to be sold, that you have your legal documents in order, that your financial statements are in order, your tax returns, and any other contractual documents you have, and that you have reviewed and analyzed any operational issues that your company may have so that you have answers to questions that prospective buyers might have. Next is you with your professional advisors will analyze your company results and determine the proper positioning for a sale, and that is determining a sales range. How is your company doing compared to others in the industry, and what multiples, that means a multiple either of sales or a multiple of profit, that companies similar or typical to yours normally sell for in your industry and in your region. Next is a determination of a strategic and optimal buyer pool. Who are the likely buyers for your company? These are the persons that you'll be marketing your business to. And who are those? Are those competitors? Are those larger companies that are seeking to consolidate and roll up smaller companies into bigger ones? Or are they just new buyers that would be entering your marketplace? After that, you prepare initial marketing information. This is the marketing information that is going to go out to the buyers. It'll be a summary of your company, of your history, and the prospects and the results that your company has obtained. Prior to transmitting any of this information to prospective buyers, we'll have already prepared, and you will already have prepared, non-disclosure and non-solicitation agreements. These are documents that protect your company against individuals just seeking to get your information and then go try and recruit your employees to steal your customers. So these are important documents. So these are usually prepared with the help of an attorney. After this, you market your company to your prospective buyer pool, and you exchange limited financial information. You give them the summaries, and then you'll start to give them limited financial information. From this, you will have one or more companies that will become interested in buying your company, and you'll start the negotiation process. So you start negotiating back and forth over a price and terms that will be included. Once you roughly come up with the terms and the price, this will be reduced to contract. It'll either go through a stage where first you might do a letter of intent that the parties are intending to close along these terms and conditions, or oftentimes you'll go right to contract where you will outline the terms and conditions and sign a contract with the buyer or the prospective buyer. From there, and always included in the contract, will be a detailed due diligence period. This is a period where the prospective buyer comes in and analyzes your financial information in detail. This is usually with the help of either their broker, their accountants, and their lawyers. They come in, they're going to, at this point, probably meet some of the key employees, and they will ask for additional information. They'll go through your tax returns. They'll go through your financial statements. They'll go through your bank statements. They just want to get comfortable that the information that you've given them is accurate. So this due diligence period occurs after contract and before closing. During the due diligence period, certain issues may or may not come up. And if issues come up, these usually get addressed, and these will usually be fine-tuned in the contract prior to a closing. Next, and usually with the assistance of your lawyers and your broker and or your accountants, you will prepare the closing documents. These are documents that are going to be executed by both the buyer and the seller in order to transfer your company to the new owner. After that, you have your closing. This is when all the documents are signed, and the money or other consideration is transferred from the buyer to the seller. After that, you'll have post-closing issues and transition issues. The seller of the company might be staying on for a certain number of months or during a transition period. He may continue to work there for a year. He might be helping them transition for 6 months, or it may be a situation where no transition is really required. Usually there are reconciling items that occur post-closing. This would be items such as allocating expenses properly between the buyer and the seller, collecting of receivables, and other such matters. So these usually occur after the closing. And last but not least, you may have some holdbacks where some of the consideration is held back for a certain period of time, depending on review to make sure that no surprises come up. Or there might be earn-out agreements, and these are agreements where part of the consideration is based on how the company does afterwards. Again, this is just a brief summary of the steps that are involved. Much more information can be found on our website at Brokers.Law. Thank you.